Welcome once again to Lehto's Law. Here's Steve Lehto.
Once in a while, there's a story that's covered by everybody. And I look at it and go, I'm not quite sure if that's for my channel or not. And I got a lot of people asking me about this story. And I'm like, I'm not really sure how much of a story there is. But then I got a note last night from Christine. And she said, Steve, are you going to do this story or not? And I admit this actually happened a week or two back. And it was widespread, the coverage of this story. And what happened was an attorney in Michigan filed a document, a complaint, a lawsuit in federal court. And the federal judge who looked at it, a United States magistrate judge, looked at it and noticed that the paper that the complaint was on, which of course is virtual now because it's all e-filings, but the document had a watermark on it. And the watermark wasn't the kind where you got to hold it up to the light and get it just right to see like the name of the paper or something like that. But it was a purple dragon wearing a suit and a tie. Now, I guess many people are going to say, but Steve, is that a lot like the lawyer dogs that you've got on the set? Well, kind of. I guess it's the lawyer dragon. But of course, I don't watermark that onto my pleadings. And this one is purple. And I'll put up an image if I can get a grab that'll work on screen so you can see what it looks like. But it is very obvious. And it actually makes the document a little harder to read. And I guess if I have to say anything as an attorney about this pleading, I will say one thing. And that is, if you are filing a complaint in federal court that is 12 pages long, and you watermark every single page with a cartoon purple dragon, it tends to make the pleading look less serious. And here's the thing. Law firms and attorneys do have to market themselves, otherwise no one will know they exist. But the question is, where do you draw the line between marketing and actually just doing your job, which would be the pleadings? So the attorney files this document in United States District Court, Western District of Michigan, Southern Division. And the court, upon seeing the complaint, struck it, issued an order striking the complaint, meaning that the judge is saying, we're throwing the complaint out as if it had not been filed, and you need to refile it. And the entire order is quite short. Order striking complaint. Each page of plaintiff's complaint appears on an e-filing, which is dominated by a large multicolored cartoon dragon dressed in a suit, presumably because she is represented by the law firm, and they call themselves dragon lawyers. And it says, see complaint ECF number 1. That's the filing number. Federal Rules of Civil Procedure, sub F, sub 1, allows a court to strike from a pleading an insufficient defense or any redundant, immaterial, impertinent, or scandalous matter. Use of this dragon cartoon logo is not only distracting, it is juvenile and impertinent. The court is not a cartoon. Accordingly, it is ordered that plaintiff's complaint is stricken, period. Plaintiff is directed to file an amended complaint containing the same allegations as the original complaint without the cartoon dragon by no later than May 5th, 2025. It is further ordered the plaintiff shall not file any other documents with the cartoon dragon or other inappropriate content, and is dated and signed by a United States magistrate judge. Now, notice how short that is, and notice what the court says. And the court, and this is the thing that I think is important to understand, the pleading is Jane Doe versus Clinton County. So Jane Doe is the plaintiff. I understand that's a pseudonym, but for the purposes here, understand there's a plaintiff filing a complaint, but the attorney's actually filing it. But the attorney's doing the work on behalf of a client. And so the court is saying each page of plaintiff's complaint contains this stuff. And it is ordered that she is directed to file an amended complaint. So in other words, the attorney is the one who obviously did this. But remember, he's working on behalf of a client. And I think the court is pointing out that, yeah, that's nice that you market yourself, and you can market yourself any way you like, but understand that underneath all of this is a complaint being filed on behalf of an actual person. And so the court found this to be impertinent. Now, you might be wondering, what exactly is the definition of impertinent? Well, not showing proper respect. And some people say rude. It's rude. But here I think it's actually not showing proper respect. And you have to understand, and I've talked about this distinction before, in many places, state courts are a little more informal than federal courts. Federal courts sometimes take themselves much more seriously than state courts. Now, you might say, Steve, that's not fair. The courts should all be the same on some level. And on some level, you might be right. But I'm just simply telling you how things are. And I've seen people do things in state courts that they could never get away with in federal court. So I don't know if this person has filed pleadings in state courts with the Purple Dragon, whether he's ever gotten a comment on that. And I also don't know if he's filed it with, the Dragon in federal courts before. I saw some indications that he might have. But it's one of those things where if my opponent filed something like that, I wouldn't file a motion or complain to the court or anything, but I'd kind of wonder, what's going on here, because pleadings are usually quite formal, very formal. So let's get back to the Federal Rules of Civil Procedure, the FRCP. Rule 12, and 12 talks about pleadings, the actual pleadings, the documents. And keep in mind, these are all now electronically filed documents, but imagine it's a piece of paper, right? So motion to strike. And a motion is when you ask the court to do something, or if the court does it on its own. But a motion to strike, the court may strike from a pleading an insufficient defense or any redundant, immaterial, impertinent, or scandalous matter. So if you wrote something in your complaint that was scandalous, the court could say, we're going to strike that. Now, more often than not, you see them striking portions of a complaint, saying count 3 is stricken, or this one phrase in this one paragraph is stricken. But here, because the watermark appears on every single page, the court is striking the whole thing and saying refile it. And it says the court may act on its own or on a motion made by a party, either before responding to the pleading or if a response is not allowed within 21 days after being served with the pleading. So the court can do it or the other side can do it. And so here the court looked at this and said, I think that's impertinent. And so impertinent's not a word we use a lot. I don't use it a lot. It may have popped up on Perry Mason, maybe. I'm trying to think. Or scandalous or immaterial or redundant. And of course, redundant stuff wouldn't be that big of a deal unless it really made the pleadings just get out of control. So that could happen. But keep in mind that underneath all of this is a 12-page complaint making some very serious allegations on behalf of somebody who is appearing before the court using a pseudonym. So therefore, the attorney, more so than normal, is, in essence, the face of the plaintiff, to the court. And the court gets this document filed, and it's filed in the name of the plaintiff with these cartoon dragons on every single page. And the court says, we find that to be impertinent. And the amazing thing is how widespread this case has been reported. I saw it, I believe, in the New York Times. I saw it on Ars Technica. I saw it on Reason.com. I saw it on Boing Boing. I saw it everywhere. And in fact, to pull the case up itself, I simply typed in federal court Purple Dragon, and I found it. Now, some people are going to say, but Steve, you understand that's the point. This guy right now has become famous. And isn't all publicity good publicity? It might be. I don't know. I just know that I wouldn't want this kind of publicity. But, everybody's got their own way of handling their own publicity if they're trying to market themselves. So there you go. So to Christine and everybody else who sent it, thank you very much. I appreciate that. It is an interesting story. It'll be 15 minutes of fame, if nothing else, for the attorney in the law firm. Dragon Lawyers. And they call themselves award-winning lawyers. And they put that in quotes. So it must be true. But yeah, a court on its own motion has stricken the complaint filed by a plaintiff where every single page contained a big ol' purple suited up dragon lawyer. Questions or comments? Put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Campers are nature's way of feeding mosquitoes.